All rise. Appeal are heard in the matter of James and the White Lion Hotel.
Yes, Mr. Weir.
All right, these relationships. One of the issues that was raised yesterday was as to whether the Volenti defence applies or does not apply when a defendant's breach precedes the claimant's conduct. And that's an issue which was addressed in one of the authorities to be put before the court, which was the Morris against Murray case. And that's a supplementary bundle of authorities. The court will kindly turn it up at page 325. The judgment of Lord Justice Fox. That's page 325. Down at G, he's considering the judgment of Mr. Justice Asquith in the case of Dan, which was obviously a case of some importance back in the day. And he says Asquith J himself raised the same question in Dan. He drew a distinction between two kinds of case. First, where a dangerous physical condition has been brought about by the negligence of the defendant, and after it has arisen, the plaintiff, fully appreciating its dangerous character, elects to assume the risk. In that sort of case, Asquith J regarded the Volenti maxim as capable of applying. It would seem sufficiently clear from that passage that it applies there. The issue for the court was whether it applies in the converse position. And you can see the remainder of the passage down at H and over the page. We don't say there's some rescue test where all that we need to establish is the risk was reasonably foreseeable. We know the judge made that finding in paragraph 103. That was that important paragraph in the judgment right towards the end. Section nature wishes to go, it's back in the core bundle. It's page 83 of 88. And at the bottom. That was that clear finding. The conduct in question was, in my judgment, reasonably foreseeable and dealing with the scope of duty. We accept that Volenti is Volenti because that's the effect of section 2.5. Can I also take you, please, to Clark and Lindsell?
Well, just sorry to go back to paragraph 103, Mr. Weir. Secondly, broadly speaking, conduct in question reasonably foreseeable. In the scope of the risk created by the defendants, that a visitor may open the low part of the window and lean out. Now, is that really what happened here? Because on other findings in the judgment, it's clear that the deceased did more than merely open the window and lean out. He sat on the sill in a precarious position. See paragraph 118 of the judgment.
Lady, yes, but he's dealing with the relevant conduct. He's chosen to describe it in short order in paragraph 103, but he's not dealing with separate conduct. If he's dealing with separate conduct, then he would be addressing the argument that there's a break in a chain of causation on that basis. It's addressing the argument that the actual specific conduct of the claimant of the deceased was such as to break the chain of causation. So he is not having regard at a higher level of generality. He's having regard to the conduct of the deceased, which he has put in short order in para 103. There can be no doubt that he's referencing the conduct of the deceased. And that was the conduct of the deceased. The conduct is not inaccurate to describe him. He was a visitor. He opened the lower part of the window and he did lean out. The mechanics by which he achieved that outcome involved, as the learned judge found, him sitting on the windowsill him awkwardly holding the defective window sash and leaning out. All of which the judge knows. He's made those findings.
All right.
Clark and Lindsay at page 434, please, in the same supplementary authorities bundle.
Sorry, 400 and...
434, please.
Thank you.
It's paragraph 3, 110, and we've sidebarred it. And your ladyships will see it starts, further conceptual confusion stems from the notion of the claimant's agreement to accept the risk, which can be express or implied, and has been held to be possible both before the relevant act of negligence and after the defendant's negligence has occurred. Can I invite you, please, to read the remainder of 3110 as sidebarred? May I just return to the observation of my Lady Justice Laing, just to allay a concern that I have, and forgive me for making this almost sound personal, but my Lady Justice Laing will record a judgment that she gave in the case of AA against Unilever PLC.
No.
Your ladyship gave a judgment in which it was on a jurisdictional dispute
Right.
involving assault on people in Kenya.
Oh, yes, I do remember that.
Whether or not there was liability on the parent company Unilever PLC. Your ladyship made findings in relation to the issue of reasonable foreseeability, which issue we appealed. We didn't have that issue resolved because we lost on the issue of parent liability in the Court of Appeal and were not given permission to proceed further. But I had put in a skeleton argument addressing the issue of reasonable foreseeability by reference to the case of Attorney General Hartwell, a decision of the Privy Council and the judgment of Lord Nichols. And that case makes clear beyond doubt that the issue of reasonable foreseeability does not go to the specific, very super specific acts of the person. It's the kind of harm and the kind of damage. That was, very respectfully, the issue that we took issue with when your ladyship found against us on that sole basis in your ladyship's judgment. So just for the avoidance of any doubt, I would wish it to be to make the submission, and I'm sorry to be seeming to be again raising another case that's not before London, but this would be what I would call ordinary personal injury law, and not one that needed it. But the authorities, Attorney General Hartwell, is a very, very clear exposition of the law by Lord Nichols. It couldn't be clearer. Something like 2004 appeal cases, something like that. Lord Nichols sets out the test with which those practicing are well familiar. Otherwise, one would have to predict accurately every single aspect of human conduct, which one can't. One has to only to predict or understand what's reasonably foreseeable, which is that someone may make use of this window, lean out and fall out. And that's the material risk which was in play in this case throughout. People can then achieve the undesired outcome of falling out by a number of routes. And there was once an expression by Lord Denning, I think it was, that the precise concatenation of events is not an issue. It doesn't have to establish knowledge of or foresight of the precise concatenation of events. One simply has to establish foresight as to the kind of harm which is going to result from that danger. And I've sought to go through where we are on the evidence in this case, and that's what the judge is doing here. It doesn't matter. In any event, he has in mind the factual premise in this case. Of course he has it well in mind. But that level of foresight to that level of specificity is not and has never been required. It would denude the force of protection of the civil law. It wouldn't be functional would add a requirement at every stage.
As we're dealing with 103, can we just look at 104?
Yes, ma'am.
Because there the judge is moving on and saying there was a high but not a very high degree of unreasonableness, clear misjudgment, but an act that others, particularly smokers, might take. How do you put that one into the equation? Or balancing act, or call it what you will.
My lady, para 104 is a reference to the deceased's conduct.
It is.
And that deceased's conduct falls squarely within the want of care that the occupier is required to anticipate when setting its standard of care under section 2.2. It's all of a piece with the finding of contributory negligence. I won't rehearse the findings at 63B and 63C, but it draws one back to those findings at 63B and 63C. It's a usual activity or normal activity to open a window. That's the very purpose of the sash window. We then have all of the circumstances, and I'll return to these surrounding the actual event, all of which make it clear that we're dealing here with undoubtedly a mistake by the deceased, for which he's unfortunately paid the highest of prices. Whilst at 3.110, may I just identify for the court that there is a footnote below it referencing, it's footnote 408, so on page 434, Supplemental Authorities Bundle. And in the section above, the authors of Clark and Linsell reference Lord Hoffman and his analysis under the free will section of his judgment. And then there's the footnote 408, and this is the learned authors seeking to justify the judgment below.
I'm sorry,
My lady,
I'm
yes.
sure I got the wrong page. Just
It's the Supplemental Authorities Bundle, page 434.
All right, thanks.
Sorry. 434, footnote 408.
Right.
It's coming after Lord Hoffman's Obiter Dicta, para 45, under the heading Free Will. And you'll see, on the other hand, where an occupier is in breach of a mandatory requirement of the criminal law, the approach adopted in Tomlinson may not apply, possibly on the basis that there is no genuine and informed choice to run risk by the claimant. And then it continues, or on the basis there should not have been an available choice given the requirements of the criminal law. And the latter part of that doesn't wash. But the former part is an indication, I'll just take the court to it now.
The authority that's cited for that proposition is this case.
My lady, it's the, I've made that submission, it's not so much as I read it, them citing this case as an authority, is them seeking to explain this case.
Right.
It's why they describe it possibly. May not
Okay.
apply, possibly. It's not the key that unlocks the door from my perspective.
No, but what are we, I mean, what in your submission are we to make of footnote 408?
What we're to make of it is what they're doing is referencing exactly the issue that I'm homing in on, which is that we don't have a genuine and informed choice to run the risk. So it's the first part. They are seeking to provide an explanation for this case at first instance. And that's the proper explanation, not Volenti.
So can I just get this right? Are you saying there was no genuine and informed choice to run the risk because he was in the bedroom at a certain time and
Absolutely.
that was the window he was presented with.
Absolutely.
That's
right.
it, is it?
Yes, he's been, and at night, and all the surrounding facts I'll come
Yeah.
back to, but I don't want to rehearse
Yes,
them
you've
too
got
many
those.
times
Yeah.
for the court. But absolutely, taking into account all of the circumstances in this case, the findings of fact, I'm going to seek to draw those threads together in a moment, if I may. Yes, my lady, the appellant needs to show that the deceased consented to the appellant's breach of its common duty of care, which produced the risk of his falling out of the window. Breaches, as set out above, involved two of them. First, the window sill being sufficiently low relative to the visitor's centre of gravity that on this account it presented a risk of the visitor falling out of the window. That, as we've seen, is paragraph 63b of the judgment. And secondly, the sash mechanism being defective. So with that in mind, and then returning to paragraph 76, if the court kindly will.
But just pausing there, Mr. Wheeler, the judge didn't rely on the fact that the sash mechanism didn't work.
My lady, he doesn't appear to. He's raised it. It sort of then got left where it lay. I'm making the submission based upon my earlier submissions, as I've indicated, as set out earlier, which were to the effect that the judge either implicitly did or should have made a finding that there was a causal breach.
It's within your respondent's notice.
It's my respondent's notice. I just didn't want to have to
No.
rehearse all that over again. So, of course, that's an issue, a prior issue for this court to determine. Because we need to look at what are the breaches to get before we get to the consent issue. So I'm going to run with both. This court will have to determine whether I'm right to do so. Paragraph 76 is on page 74 of 88. And we can actually pick it up from the sentence in my judgment. It's Corbin. Page 74, paragraph 76. In my judgment, a deceased will have recognised that if you sit on a windowsill, part out of the window, there is a risk you may lean too far or lose your balance slightly and fall. The deceased chose to sit on the windowsill and accept that risk. There was no hidden feature or element he knew the sash window had to be held up. Nowhere does the judge say that the risk to the deceased that he was liable to fall because the windowsill was so low was a risk he even understood or knew. Nowhere does the judge say that the combined feature of the low windowsill with a defective sash mechanism rendered him again at increased risk by virtue of the defective sash needing to be held of falling out. And that's just on the issue of knowledge. What is set out in parentheses does not address that issue. He knew the sash window had to be held up. Correct. Of course, because it falls down if you don't hold it up. But he didn't know, or there's no finding that he knew, that the combination of being at risk as a result of a low windowsill and then having to hold a sash window up rendered him, as plainly it would do to us now, full benefit of reflection on the matter after the event have increased his risk of falling out. So describing there is a risk that you may lean too far out of a windowsill, and if you lean far out enough, you may fall, is in one sense a statement at a very high level of generality. If one takes a window and one leans out of a window sufficiently far, one may fall. But that's not the risk. The risk is, as a result of the windowsill being so low, this is now a problem you face when otherwise you wouldn't do. You wouldn't have to address this notional issue were it not for the fact that the windowsill is so low. You then sit on it, a normal activity, and now you're sitting on it, your centre of gravity is starting to go in the wrong direction. You're starting to shift your body weight, so it's at best going to be somewhere around the threshold, and can very easily now, depending on where you put your torso, you don't have to get embroiled again in the hole, it's 2 feet, because this is just part of the judgment. Where you then put your torso, you are now liable to put yourself in this particular difficulty. That's knowledge. And of course, a fortiori, nowhere is there a finding that the deceased either knew and expressly or impliedly accepted that risk. And that's accepting the risk created by the defendant's breach of duty. In other words, the way I might put it is forgiving the defendant for its breach. I know you've set out a windowsill that's too low, and I know you've produced a sash mechanism that's defective, but I forgive you. I waive my legal rights to sue you. There's no such finding in paragraph 76. The court would have to work up a tremendous head of steam to seek to drive one out of those findings. They don't get close in our respectful submission. If, and to the extent that against that submission the court finds that the judge did so find, it's not whether he intended to, it's what he found that counts. Not what he thought he was finding, it's what he did find. It's what he did hold. Whether he had it in his own mind that this would be a bar to the claim isn't the point, because we're now, by the process of legal analysis, in the world of Volenti, and the only question is, did the judge make findings that satisfy the high threshold of Volenti? Not scienti. If, in the face of those submissions, this court finds that he did make such findings, then they are challenged via the respondent's notice. And I refer the court back, but more by way of oral submission than necessarily inviting the court to reread now, but to look to our respondent's notice, which is fairly detailed at page 28 of the core bundle, and our skeleton argument at paras 38 and 39, which are pages 47 and 48. So what the appellant is suggesting that this court should do is as follows. We start out with the defendant's case, and may I just take the court to the pleadings, statements of case. This isn't to take what I would call a pleading point. I'm not saying they're debarred from running this, but it is of note to see how the case has been defended. So we're in the supplemental bundle, which, if it's not tabbed for you, and if it's not cut off at the top, would be tab 4, page 11. But if it is, it'll be 11 pages in.
Yeah, we can just about pick out the number, thank you, at the top.
Very good. Here is the defence. Obviously, it will need in due course to be read with the particulars of claim, but I won't take time up by going to the particulars of claim here. And if you go on to page 12, paragraph 9, The defendant denies the allegations of negligence, breach of statutory duty, breach of contract. In relation to the individual particulars, A is denied. The defendant admits it didn't carry out any risk assessment in relation to the risk of falls from the window of guest bedrooms, denies this was causative of the accident, continues down, and then he sets out, because the risk which caused the accident was a guest choosing to open a window to a sufficient height to enable him to lean out the window, to do so to such an extent that the descent of gravity is outside the room and without maintaining a secure handhold and foothold, which was not a risk which the defendant could reasonably have foreseen and guarded against. And to like effect, if you go over the page to F, the risk of a person falling through the window was non-existent unless the person chose to open a window, crouch down while at the same time deliberately preventing a window from closing and then proceed to lean out of the same. This was not a risk which was reasonably foreseeable or which it was a duty of the defendant to guard against. You then have the allegation of novice actus indeveniens at para 10, denial that the conviction is of any relevance at para 11, and allegations of contributory negligence at paragraph 14. No case ever being pleaded using the words Volenti or reference to section 2.5 of the Occupiers Liability Act. So here is a risk to a visitor that, per the defendant's pleaded case, is not a risk that the defendant could have foreseen or guarded against. The appellant conducted its own risk assessment of the rooms and yet failed to identify the risk of falls due to the window sills being particularly low. And we see that from the sentencing remarks of the Crown Court judge, which is at page 23 of that supplemental bundle. It's just having to drive on, you get to the agreed basic plea for which you may have a sticky on, and that'll be the next page. And you'll see pretty much in the middle between the two hole punches, paragraph that starts, the duty of the hotel was to assess the risks to persons using its premises, notably guests, and a risk assessment had been undertaken, but that's just a typographical error, in 2013. And it continues, you can see lower down that paragraph. This is important because it means that the failure was to appreciate the risk of falls from windows. I think it's because of that that you see the particulars of offence at page 17 are between the 1st of January 2013 and the 10th of July 2015, because that's when the risk assessment, I think, was done. That's page 17. This was the appellant's property, and of course it had the opportunity to call in experts if it so wished. It could conduct an assessment at any time of day or night, at any time from January 13 to July 2015, to take into account the range of anticipated activities of its visitors. Yet it failed to pick up on a hazard associated either with the window sills being low or indeed, we know the sash was defective, we don't know for how long. The position of the deceased can be contrasted. Here was a visitor who turns up on a day, does use the window and have a smoke before a wedding, but we're not in a world, as we know, of Ciento, and we're not in a world where having a smoke indicates that he understood those risks associated with the sill being low. He then comes back from the wedding. It's very late at night. He's tired. He's drunk to some degree. He can't sleep. It's very hot. and he opens the window. Those are not the actions to which one should attribute the Volenti level of knowledge and assumption of risk by agreement relating to breach of duty. The appellant didn't pick it up at all in the cold light of day. But this tired, hot, drunk visitor should be held to account on the basis that he did or should be found to have done so. It is unsustainable, respectful submission. All of this is of a piece with the judge's subsequent findings. See, first, his finding at para 104 is observed by my Lady Justice Nicola Davies, and then when he makes his actual findings of contributory negligence, albeit in short order, at paragraph 118. That's page 86 of 88. And there is the judge rehearsing again the judge's assessment as to what it was that the deceased was doing, and translating that into contributory negligence. And he was right to do so, in our respectful submission.
So how do you marry or equate, use whatever phrase you want, the judge's findings at 118 with 103?
Well, ladies, 103 stroke 104.
Yeah, well, particularly 103.
My lady, yes. The conduct is foreseeable. We have a duty on the occupier which has been breached and which is a cause of the deceased fall. As is so often the case, you can have more than one cause. And you can also have the deceased's conduct himself being culpable, and that's the finding of the court. And that's how the two marry. I don't know if that assists, but it's a contributory negligence is an acknowledgement that he did something wrong. And he did, and we don't shy from that. But it doesn't mean that the occupier didn't do something wrong. It's only in this extremist position of the Volenti defence biting that an otherwise culpable occupier can avoid all liability. What we have here is a recognition that both parties are to blame. Forgive me, Valena, I'm perhaps may not be addressing the issue, but I don't, in that sense, see a conflict between the findings relating to the appellant and the findings relating to the respondent. What they do is inform the court as to how the judge, or what the judge was finding in paragraph 76, because what he was finding was a prelude to his making his findings in relation to contributory negligence. And I've referenced earlier how this is how it should be per the authors of the relevant textbooks. And can I just go back to Clark and Wenzel, because I don't think I've taken this passage. It's the Supplementary Authority Bundle, and it's page 449. didn't sidebar it. I probably should have done so. Can I invite the court to read all of 3134, please?
Is the breach of statutory duty that's referred to in this paragraph a breach of statutory duty giving rise to civil liability?
It will always be in this. I can't. Yes.
I just want to be clear about
Yes,
that.
my lady.
So, the breach of Section 3 of the Health and Safety at Work Act doesn't engage the principles referred to at the beginning of the paragraph.
No, there was a time when, and if your ladyship goes back to page 445, there was a suggestion that you couldn't have Volenti at all if the claim was one for breach of statutory duty. You'll see it's at 3128.
Mm-hmm.
We're in the world where we've got Section 25, so
Yes.
it's just not our bag. I don't have to consider and address those issues.
No, well, I was just wondering why you were referring us to this paragraph, but
My lady, I'm referring to this paragraph because what the learned authors are focusing on is how, first of all, you see in the middle, the gist of contributory negligence is that the claimant didn't think as he should have done. But the reference for that is see Lord Reed in Shatwell. I couldn't actually find him saying that at that back page, but it may have been me missing it. It's a very...
sometimes the textbooks don't have the right page numbers.
Yes, but I would have scanned around it anyway, I didn't find it. But it's a very effective way of describing it, not least in the context of this case, when you think about the circumstances at night, tired, drunk. So we just didn't think about it in the way that, for instance, the occupier should have done in the cold light of day, conducting a formal risk assessment. He still gets hit for that by way of contributory negligence, but it's contributory negligence. Secondly, because again we have, my lady, the recitation that you can have more finely adjusted justice between parties by an apportionment. And thirdly, we have a reference down, again, to the Morris and Murray. I said I was emphasising the facts of Morris and Murray for a purpose, and I was going to come back to it. And that's because if one stands back, it doesn't matter that that was negligence which occurred after the voluntary assumption of responsibility by the claimant. The important point is it was so obvious to the claimant that if the claimant got into a light aircraft with a man who was incapable of flying that aircraft safely, he was indeed liable to suffer, brackets, very severe injury as a consequence.
It's an aeroplane. Yeah.
But that's the point. That's why I described it as the paradigm, because it has to be what I described yesterday as front and centre. It has to be that obvious to you that you have expressly or impliedly waived your right to sue the defendant for his obvious carelessness. And that is so far removed from a man at night, and again I'm back to rehearsing those facts in this context.
Well, I suppose you could make the point that the choice in the judgment between a finding of Volenti, well, I say this judgment, but for any judge, between a finding of Volenti and a finding of contributory negligence, is a paradigm case of a matter for the trial judge.
Lady, it is.
Okay.
It is, but actually, if for instance, a judge was held to have made a finding of volenti, then that's a point of whether one calls it law or evaluative judgment tends to be rather. I had an outing recently in which Lord Justice McComb indicated that the mere fact that I'd shown him a judgment for Lord Justice Tomlinson saying setting the standard of care was an issue of law was not to the point, because he was going to ignore it, because it was, as far as he was concerned, an issue of evaluative judgment.
But Lord Justice McComb is very keen on that differentiation.
So I defer to the court as ever on these matters, but it's an appealable issue, if I can put it that way. There are none of the difficulties in getting to the point of appealing in relation to that, because there is a test, and either that test has been met or it hasn't. So that's the prior issue.
Sure.
But after that, as your ladyship's indicated, it is difficult, stroke impossible, to reconcile the finding of contributory negligence that the judge has made based upon those self-same facts with either A, an understanding that he did make a finding of volenti, or B, that he should have done. And we have such a steer. Back in Lord Denning, we've got the Nettleship case, which is then referenced in Clark and Insulin's passage and so on. So that's why I refer to that passage.
I mean, it comes back to the point you were dealing with yesterday afternoon, and forgive my simplistic phraseology, but it is such a high test, isn't it?
It's such a high test, deliberately so. I mean,
Yes,
they were described, I think, common employment, contributory negligence, and volenti, somewhere in Clark and Linsell, described as one of the cases as the three, not evils, but they just made it impossible for employees at the time to get started in the 19th century. And we moved on from that. And Lord Denning says that. He says, look, back in 1891 in Smith and Baker, the House of Lords moved on from this and said, actually, this idea that knowledge is enough doesn't wash. It's got to be volenti, not sciente. That's way back in the day. And the OLA, as we've seen, Section 2.4c, Lord Denning in Nettleship and Weston, then changed it in relation to occupiers' vulnerability, effectively overruling Horton's case, the House of Lords case that preceded the OLA. Lady, I will, if I may, just trespass a little bit further on the court's time, only because my own friend has prayed in aid so strongly his three cases after Tomlinson, which were Poppleton, which I've already addressed, Geary and Edwards. So may I just, in short order as possible, deal with Geary next, which starts in the core bundle of authorities at page 51. And if the court kindly goes to page 63, first thing that Mr. Justice Coulson did, this is the Bannister case in the Newcastle pub. First thing that Mr. Justice Coulson did, see paras 44 to 48, so page 63, is to dismiss the claim on the basis of Volenti. See para 48. If I'm wrong about that and the claimant's voluntary assumption of risk is not the start and finish of her claim, then he continues. And there's all this point at para 44 my learned friend draws attention to, that counsel for the claimant could draw the court's attention to no authority, etc. None of this matters, because if and insofar as this is an assessment that we're not in the Occupiers Liability Act, then it's not our case. If this is an assessment that there is no liability under Section 2.5 of the Occupiers Liability Act, then respectfully, matters have been taken in the wrong order, because we need to go through Section 2 to get to Section 2.5. And actually, the ratio of this case is found at paragraph 59, certainly from our perspective, page 66. Where he holds, see the part we've sidebarred, but there was nothing unsafe about these premises and no danger attributable to their structure. There could therefore be no liability under the 1957 or 1984 Acts.
And those are critical findings, aren't they?
But are critical. Yeah. They really come first. Depending on how one interprets paras 44.
You would say that's the 2.2 finding.
Well, no, that's section 1 finding.
Sorry, section 1.
Yes.
I meant, sorry.
Yes, that's the section 1 finding. What I call engagement. One can describe it in different ways, but because when a description, there can be no liability under the Act, could mean for a number of reasons, but it means because the Act's not engaged, is how I prefer to describe it. So the Act isn't engaged, in which case we are in Tomlinson territory, because we're in Tomlinson, Poppleton and Geary territory, which is, we're now looking at a common law duty of care, and now we can apply to our heart's content Lord Hoffman's dictum in Tomlinson in relation to a claim in common law negligence. But that's not this case, and so that's Geary. The decision in Edwards is less straightforward to interpret in one sense. It starts at page 32. Say less straightforward for these reasons. If we start then at page 45, we've sidebarred paras 42 and 43. Just starting the second part of para 42, so pretty much where the lower hole punch is. Sorry, it's page 45. Para 42, and in the part near the hole punch, Lord Justice McComb says, "It seems to me that a bridge with no sides or only low ones may present a danger from the state of the premises, such as to give rise to the common duty of care," which on its face would suggest that section 1 has been crossed and that we're in section 2.2 territory. He then carries on. I won't read out, obviously you'll be able to read please the remainder of that paragraph. And then he says, "The reason for this answer lies, I think, in two well-recognised principles of law," and I'm going to take those separately. So first, there is the proper treatment in the law of the concept of risk. And just pausing there, what Lord Justice McComb then does, if you then loosely hold the sheets of paper and go 45 through 46, through page 47 to the end of para 46, where it rather abruptly stops, is he's looked at a number of passages, including the one I've taken the court to in Tomlinson at para 46 about the balancing of foreseeability against preventative measures, etc. But one could be forgiven, in my respectful submission, for thinking that that's an assessment that should have been made earlier when determining whether there was a danger. Because whether there's a danger is whether there is a materially foreseeable risk of injury. And Lord Justice McComb's beef, if I can put it that way at this point, seems to be, or very close to, that there isn't. So he's made an assessment as a danger, but that actually is the part at which he should be assessing whether there's a materially foreseeable risk of injury. So it may be that one way of looking at this case is in truth that we'd never have an engagement. But that is, I wholly accept, not straightforward in the sense that that doesn't appear on its face to be the intention of the judgment. But we then have the second sentence at paragraph 43, which is occupiers of land are not under a duty to protect or even to warn against obvious dangers. Both these propositions appear in the speeches in Tomlinson's case. And that is the assertion or statement by Lord Justice McComb, which very respectfully we take issue with and we have done throughout, set out in our skeleton argument. We can't get from Tomlinson's case, if and insofar as Lord Justice McComb is now seeking to employ this at a section 2.2 stage, the full force of Tomlinson. Because as we've seen, Tomlinson is not even an OLA 1984 case, let alone an OLA 1957 case. And even his obiter dicta was that if it's not If it is an 84 case, it falls out at section 1.3c stage, which doesn't exist for obvious reasons in relation to the duty owed to a visitor. So we just don't get to that point. Otherwise, we would be back in the world that Lord Benning said we were rid of, which was this idea that sciente suffices.
So are you saying that this decision is per incuriam?
Lady, I'm not sure I have to go that far. And I don't ever wish to go further than I need to.
No.
Because
Well,
I
I mean, what are we to make of it? 'Cause
well,
it
my
is a
lady, what
decision of the
I've
Court of
sought
Appeal.
to do, and we set it out in our skeleton, I'm just coming to this part now,
Yeah.
is if you go ahead to paragraph 60, you actually have a conventional assessment under section 2.2.
Right.
In that what we can see, and Lord Justice McComb set this up with the last part of his paragraph 46. Sorry, I'm jumping around like crazy, but page 47, paragraph 46, the last sentence, he said, while there are limits on social value in the case of this sort, the amenity of this bridge as a feature in the park shouldn't be ignored entirely. And he then picks that up again and runs with it, if I can put it that way, paragraph 60, because what he does is he conducts his balancing exercise, and he has on the no higher standard side of the equation the amenity value, last part of para 60. Such additions, this is a barrier on the bridge, would have altered the character of the bridge significantly and to an extent out of proportion to a remote risk. And that's whether the risk is even triggered, I don't know. That's how he describes it. Which had never materialised in its known history. Sounds to me like not reasonably foreseeable, I have to say. But if it's not reasonably foreseeable, then it's knocked out on conventional grounds that simply don't apply across to this case.
Quite difficult to tease. It's a very compressed paragraph, if that's the weight that we should put on it.
Well, my lord, my lady, it may be compressed, but it's undoubtedly a central paragraph. No doubt about that, because this is where he is addressing head-on the claim that there should have been barriers.
But you say that paragraph is the core of the binding.
That's conventional. If we're in section 2 at all, that's a finding under section 2 that in the balancing exercise, on the one hand you've got a remote risk, that should never previously materialise, and on the other hand you've got social utility, using that phrase produced by Lord Hoffman, social utility, I think is how he describes it, to keeping the bridge in its original fabric, and not effectively making it ugly by having barriers across it on its sides.
So, speaking entirely for myself, I haven't always found this authority perhaps the easiest to negotiate.
It's not the easiest, my lady, and I don't wish to put it any higher than I need to, but it isn't the easiest. Insofar as the learned Lord Justice addresses the other aspect of the claim, failure to warn, again, that doesn't matter. So I don't need to say more on it because we're not a failure to warn case. Otherwise, I would have to reference section 2 brackets 4, because that doesn't make an appearance in the judgment when the relevant statute is set out at paragraph 35. We have no reference to section 2.4 at all. Whether a warning is sufficient is a live issue, but here we have a no warning needed analysis. But we're not a failure to warn case, and then I would have to really get into that, but I don't need to here, respectfully. So it just doesn't take the court where the sentence in para 45, I think it is, no, 43, where the appellant would like that sentence to go. Put a different way, it can't support the weight of the submission and then if one puts it.
So paragraph 61 for judgment.
Lady, yes.
When Lord Justice McComb refers to the judge below setting the standard too high, what standard is he referring to?
It's
duty of care?
No, the section 2.2 has within it the setting of the standard of care.
Yeah.
and it's a section. This then becomes a Section 2.2 case. You owe the common duty of care, which is in taking account of all the circumstances, to take reasonable care to ensure that the visitor is safe, or whatever the wording exactly is. And that is a standard which you then set for this visitor. And the standard was set too high by the judge because the judge required that steps be taken, and the Court of Appeal disagreed when you perform a conventional balancing
Yes, well,
exercise.
sorry, I think you were answering my. I mean, I think that's what I'd assumed, but sorry, perhaps I didn't make the question
sorry,
very
Manu.
clear. All right.
I'm sorry. The actual finding of the judge wasn't that there should be barriers. This is paragraph 25. There was a cross appeal. The finding of the judge is there should have been a warning. Para 25, first part of para 25. So there was an appeal against a warning and a cross appeal against the no barriers.
Okay.
So that's Edwards, my lady.
So, in summary, is your position on Edwards this, that although not explicitly identified, by the time one gets to paragraph 60, it appears to be a Section 2 case, and in paragraph 60, the balancing exercise is carried out, and that is the end. That's it.
That is my submission.
Yeah, right.
With a rider vis Section 1.
Yes.
I could, and I don't know if I should, perhaps I should, because London hasn't taken the court to Staples today, but it's at large. The Staples case, a rather similar analysis has to be performed, but I'm not sure if that's helpful to the court at this stage. It's also a 1995 case. It precedes Tomlinson and so forth. I think there are so many cases. I've selected the three that the learned friend sets out and says these are the ones which are so helpful to my case. Well, ladies, unless I can assist the court further, those are the respondents' submissions.
No, thank you very much indeed. That's most helpful. Yes, Ms. Walker, anything in reply?
May I start with a learned friend's submissions on Volenti non-fitinuria? Volenti non-fitinuria was not a doctrine upon which I expressly relied, either in my oral or written submissions below. I relied upon, to the contrary, what I described as the insuperable point. And may I remind the court of the way I put it, which is the way I continue to put it. It's recorded in paragraph 77 of the judgment.
Yes. No duty.
Well, for present purposes, of course.
Sorry, do you mean 77?
For present purposes, can I just refer the court to paragraph 77, half which this is a quotation from my skeleton argument. The risk of a fall such as it was therefore one which he had created and was obvious. In those circumstances, it's the defendant's case that this claim cannot succeed. A person of full age and capacity who chooses to run an obvious risk cannot found an action against a defendant on the basis that the latter has either permitted him so to do or not prevented him from so doing. So for this purpose, all that needs to be shown, and the authorities from prior to Tomlinson, Tomlinson itself and subsequent to Tomlinson, all show that if there is a situation of danger, which is obvious, and a claimant by his conduct accepts the risk that that danger presents, he cannot succeed because no duty is owed to him in respect of that risk. Now, the law has moved on from the observations of Lord Denning 50 years ago in Nettleship and Weston, and Lord Diplock 57 years ago. The courts rarely use the expression volenti non fit injuria to describe this principle. It's not used by the House of Lords in Tomlinson. It's not used in any of the Court of Appeal cases to which I've referred the court. It's true that Mr. Justice Coulson, as he then was, said that the principle was equivalent to volenti. But
as I understand it, you accepted that yesterday when I...
I'm sorry, my lady.
As I understand it, you accepted that yesterday when I put exactly that to you.
That
Point, that section 2.5 represents volenti.
it's within the volenti. Yes, it's not. I don't accept that the maximum volenti non fit injuria is coterminous with section 2.5, nor with what I've described as the insuperable point.
So you're rather rowing back from what you
No, I'm
were
not.
saying yesterday.
No, not at all.
Well, I
not
thought
not
that
at all,
is
my
exactly
lady.
what you said yesterday.
What-
When
no.
you say so, Mr.
But,
Walker.
lady, what I pointed out yesterday was that the maxim volenti non fit injuria encompasses an entirely different category of case as well. That is to say, the case where it's alleged that the claimant has accepted that the defendant will commit a tortious act in future, accepting a lift from a drunk driver being the obvious example. And all the cases Malone and Friends cited, the three cases Malone and Friends cited yesterday, were all instances of that situation. And in those circumstances, it's difficult to establish the defence of volenti, because the claimant won't normally be found to have accepted that he might be injured by whatever the defendant chooses to do, whatever failing the defendant manifests. And so all those statements that there must be nothing short of an agreement between that the claimant will exonerate the defendant from responsibility, or that the claimant waives his right to rely upon any breach, those are applicable to that category of case. And the statements of principle in Tomlinson, Poppleton, Edwards, Derby and the National Trust, and all the other cases on this point, don't incorporate requirements that the claimant has in some way waived his right to rely upon the defendant's breach, or agreed to exonerate the defendant. All that is required is that the risk is obvious, and the claimant by his conduct in courting that risk is to be regarded as having willingly accepted it. And these distinctions between sciente and volenti and so on play no part in the enunciation of this principle.
So how does the insuperable point fit into the structure of section 2 on your
Look, the insuperable point is a principle of law which applies throughout the law of torts. It applies to all negligence claims. Section 2.5 is simply an articulation of that principle in the context of occupier's liability.
But isn't the fundamental difficulty that this claim was brought on the basis of the 1957 Act?
Lord, so was Edwards.
I'm a woman.
Lord, so was Edwards and Sutton. So was Geary. There's nothing peculiar about the fact that the claim is brought under the 1957 Act, as opposed to being, for example, a claim based upon a dangerous activity such as Poppleton. The court will recall that in Poppleton, the insuperable point defeated the claim, but as my learned friend has pointed out, that case was concerned with activities, wasn't concerned with the state of the premises. But the point doesn't depend upon whether the claim is brought in respect of the state of the premises or an activity. It's an overriding principle of the law of torts, and it's been developed in recent years, and it's been articulated many times in this court and by the House of Lords in Tomlinson. And so what, with due respect, this court and any judge is required to do is to consider whether the conditions necessary for the invocation of that principle are present. And the learned judge in this case has expressly found that they are. In paragraph 76 of the judgment, which we've looked at many times. And however many times my learned friend looks at it or tries to pick it apart, there is no getting away from the fact that the learned judge found the circumstances which give rise to the insuperable point and which would also give rise to section 2.5 being applicable, are present. And the learned judge would have found for the defendants had he not devised a forensic route for himself which was that the fact of a criminal conviction displaced this principle. And if this court accepts that he was wrong to do that, and my learned friend doesn't seem to have argued very strongly against it, because in my submission it's very clear that he was wrong, then the court is left with the finding in paragraph 76, which leads ineluctably to the conclusion that the claim cannot succeed because the deceased suffered his accident in consequence of an obvious risk which he chose to run. And I don't accept that there's a very high threshold for that principle to apply. The only threshold is whether it's an obvious risk. And all what I will, I hope not disrespectfully, describe as the baggage associated with the old doctrine of Volenti, non fit inuria, i.e. Volenti, not scienti, and so on and so forth, are nothing to the point. In Tomlinson, Edwards, Poppleton, and most of the cases, the words Volenti non fit inuria do not appear. The court doesn't say we're applying the ancient doctrine of Volenti non fit inuria. It says we are applying the principle, which appears from any number of cases, including decision of the House of Lords, that where there is an obvious risk which the claimant runs, he cannot maintain an action because he is owed no duty. And that should be the end of the case. And unless my learned friend can get round the findings of fact in paragraph 76 of the judgment, which he can't in my submission, his claim cannot succeed. Now, when the learned judge was reviewing the authorities of this case, he distinguished them on the basis, and only on the basis, that they were not cases where the criminal law imposed an overriding obligation. In other words, his own exegesis into the role of the criminal law. Can I show the court that?
But we have your submissions about the
yes,
the judge's link up of the criminal conviction on the facts of this case. Do we need to look at
yes, my lady.
Because
yes, my lady, I do ask you to look at this because it shows the basis on which the judge did not feel himself bound by cases such as Poppleton, Geary, Tomlinson, and the rest. And it's a mistaken basis. And if he had not adopted that basis, he would have regarded himself, been bound to regard himself as bound by those decisions. And I just want to show you your...
Well, very well. So I can't see how it's reply, but if you would like to, please go ahead.
My lady, I do ask you, the court to look at paragraph 70 and 71. Because
no. Yeah.
Having dealt with Poppleton, he says, I pause to observe that in the present case, the law, in the general sense of encompassing the criminal and civil codes, did require the defendants to prevent the deceased from undertaking the relevant action. And he says the same in relation to Geary and Weatherspoon at the foot of this page. Even if the claimant's voluntary assumption of an obvious and inherent risk was not a complete answer to the case, there was no doubt that the absence of any obligation on the part of the defendant to protect or prevent her from voluntarily assuming that risk provided the answer. So again, the criminal law provided imposed no obligation to prevent the relevant conduct. And that led the learned judge to adopt the position that even though the insuperable point to which upon which I had relied, even though the insuperable point was prima facie applicable because of those authorities, it didn't apply because the criminal law imposed a duty on the defendant to safeguard the claimant or the deceased in this case from his own.
But he makes a similar point about Edwards and Sutton in paragraph 74 of the judgment. Last sentence, paragraph 74.
Yes, absolutely. The same point at 74, contrasted with the present case, where given the regulatory requirements of the criminal law, the risk of dismissal would have resulted in action that would have prevented the action. So, if one strips out that element in his reasoning as being wrong, then one is left with the finding in paragraph 76. Now, I do need to reply on Malone and Friend's attempt to dissect that finding, or interpret it, so as to demonstrate that it doesn't satisfy the conditions for the application of section 2.5, or Volenti, as he would put it. What he says is there's no finding that the deceased accepted the risks to which Malone and Friend referred, posed by the sill being at a very low height, or the defective sash, and that the learned judge therefore didn't find that the deceased had accepted all the risks, as opposed to only having accepted some of them. I'm paraphrasing what he says. But that is not consistent, and indeed not sustainable with what, in the light of what the judge in fact says. And the judge says there was no hidden feature or element. So Malone and Friend's submission, yes, there was a hidden feature, the low height of the sill or the defective sash, are not sustainable. The fact that Malone and Friend can devise what he considers to be a hidden feature and seeks to persuade the court is a hidden feature is nothing to the point. The judge has dealt with that by the finding that there is no hidden feature. And there's no factual basis in my for Malone and Friend's submission that the low height of the sill at this stage plays any part in the accident, because if and once the deceased is sitting on the ledge with his feet off the ground, how far this is above the floor of the bedroom is of no consequence. He's sitting on the ledge.
Does the judge actually find he's got his feet above
No.
the ground?
No, he doesn't.
Well, it was a rhetorical question. Because that's the difficulty, that the judge doesn't clearly find exactly how he was sitting on the ledge.
No, it doesn't. But, milady, if the...
But if the theory is that he was sitting astride the ledge,
Yes.
then because of the low height of the sill, surely at least one of his feet would have been on the ground inside.
At some stage, one would suppose that. But I asked rhetorically, what difference at that stage does the height of the window ledge make? He's in a position, whether it's 18 inches off the ground or whether it's 3 feet off the ground, he's in a position where he is precariously balanced in circumstances which, if his centre of gravity moves outside the window, there is a risk of a fall, and he knows that. So it's, with due respect to Malone Friend, not open to him to suggest that there are additional risks which this court should infer to have been present, which the judge overlooked. The judge heard evidence, and he received evidence from an accident reconstruction expert
I wasn't very impressed with him.
He wasn't, and rightly so. The judge's findings were not plucked out of the air. They were based on the evidence. So where the judge finds the position that the deceased was in, sitting on the window ledge, that is not, that doesn't come from his imagination. It comes from an assessment of the evidence which was led and which was either accepted or rejected. The claimant's case was that the deceased must have been lying on the bed and with his head out of the window.
But where is all this taking us?
Well, where all this is taking it, Maloney Friend, I think, suggests that the judge's findings of fact are in some way assailable.
But only so far as the sash.
But the
mechanism, and that's simply because it's not dealt with, he says. And so he says that if the judge not adequately dealt with...
But, Lady, with respect, it is expressly dealt with in the words which are in brackets at the end of paragraph 76. Now, Maloney Friend asserts that there is some additional hazard presented by the fact that the sash...
Well, we know you say it was actually a safety
It's a
so
safety...
We know your case on that.
No, Maloney, my case was it's a safety feature in relation to the risks arising from the ordinary use of the room. What I've accepted is that this window presented some small risks to people who were using the room in the way in which they might be expected to use it. I was asked expressly yesterday what risks was I accepting were foreseeable or were risks that should be guarded against. And they are risks arising from the ordinary use of the room. And they are risks which arise. Bear in mind, of course, the indictment's not concerned just with this room, it's concerned with all of the front bedrooms in the hotel because they all have the same low window and they have different characteristics. And if a window was open, in this particular room, it would need to be held open or wedged open, but in other rooms, if a window was open, because of the low height of the sill, there's a possibility, certainly that a child could have fallen out, and I've accepted a low risk to an adult, although it's much more difficult to envisage an adult falling through an aperture which is 3 feet above the ground, but it's possible. Those are risks which flow from the ordinary use of the premises. The deceased is not using premises in an ordinary way. He's not opening, the learned judge says opening the window is a perfectly normal activity. He's not opening the window, he has already opened the window. What he is doing is electing to sit on a narrow ledge immediately adjacent to a sheer drop of 9 meters to the pavement below. That's what he's doing. And in so doing, he is courting an obvious risk. And the judge has found that to be the case. May I reply on Malone Friend's submissions in relation to the judgment paragraph 103, where the judge is dealing with novus actus interveniens?
Yes, thank you.
The judge is not dealing here with the insuperable, not dealing with the question of whether any duty is owed. He's dealing with a further submission of novus actus interveniens. And as I explained yesterday, the doctrine in fact has no application here, because the claim fails not because there's an intervening act between the breach and the damage. It fails because there's no duty and therefore no breach. But on this assumption that it could arise, what the judge says is, broadly speaking, the conduct in question was, in my judgment, reasonably foreseeable. Well, it depends what he meant by broadly speaking. He says it was within the scope of the risk created by the defendant that a visitor may open the lower part of a window and lean out. But as my Lady Justice Laing pointed out, that's not what the deceased was doing. He wasn't opening the window and leaning out. He'd opened the window, he was holding it up and sitting on the astride or on the ledge. But, as my Lady Justice Nicola Davies has pointed out, this has to be read in conjunction with paragraph 118. The judge is, of course, dealing here with contributory negligence. But his findings of fact in relation to that issue are highly material to the insuperable point issue. And they're these, where he says, 118, this was not momentary inadvertence. He could foresee the danger of falling, if not manner. And then, in my judgment, in choosing to act as he did, so he can foresee the danger of falling, and he chooses to act as he did. And on those findings, the principle as articulated in the cases to which we have referred is plainly engaged. Now, when my learned friend took you to paragraph 103 to meet a submission I had made, which was that I didn't accept that the danger posed by this particular activity was foreseeable. And I said that in answer to a direct question from the court, was I saying that this was foreseeable or not? And I was saying, no, in my submission it was not foreseeable. But I repeat, it doesn't matter whether it was foreseeable or not. The Tomlinson principle doesn't depend upon foreseeability. In theory, the risk of sliding down, posed by sliding down the banisters, was foreseeable and foreseen. In Edwards, there were express findings by the trial judge that there were risks which were foreseeable. So there's an express finding of foreseeability, and the court proceeds on that basis. So even if the defendant foresees that someone might want to sit on his window ledge and hold the window open, and thereby court a risk of falling, even if the defendant knows that and foresees that, it doesn't mean that the claimant is entitled to succeed, because what's in play here is not the question of whether there's a breach of duty, but whether there is a duty, as I submitted yesterday. And I do ask the court to, when considering the insuperable point or the principle, to consider exactly the way in which it was put in all of the cases, Tomlinson, Poppleton, Derby, Staples, Geary, and so on. And I'm not going to ask you in reply to look at those authorities again, but I am going to just ask you to look again at Edwards, on which my learned friend has made some submissions, which is in the core bundle at page 32. This was, of course, a claim brought under the Occupiers Liability Act. In dismissing it, the court referred not to section 2.5, but to the general principle which I've described. The insuperable point. And I remind the court that the starting point was that the trial judge had found that there were foreseeable risks due to the state of the premises. And at paragraph 34, the judge, in the course of an exchange with counsel, indicates what those risks were. Those are all risks due to the state of the premises. And this court was bound to start from the position that there were dangers due to the state of the premises, because the judge had so found. And then at paragraph 42, Lord Justice Bacoum says, 6 lines from the bottom, while I am prepared to assume that there was objectively a danger arising from the state of the premises, in this respect here, does this mean that in order to discharge the common duty of care arising from that objective possibility of danger, no such bridges must be left open to visitors or must not be left open to visitors without guardrails or express warnings? In my judgment, the answer to this question is a clear no. So he proceeds on the basis that there was a danger due to the state of the premises, and so section 2.5 would be, section 2 would be engaged. And yet the appeal is allowed, and the reasons why it is allowed, or one of them, is that occupiers of land are not under a duty to protect or even to warn against obvious dangers. Tomlinson. And that principle is applied at paragraph 47 and 45 of the judgment. Where there are references to Staples, judgments in Staples, And the appeal is allowed, as I have submitted, solely on that ground that there was an obvious risk against which the defendant owed no duty to safeguard the claimant. And that decision is, with due respect, binding on this court. It doesn't involve consideration of whether it's Scienti or Volenti, or whether the claimant has agreed to exonerate the defendant from the consequences of his breach or to waive his rights. It simply depends upon this being an obvious danger which the claimant courted. And that is the basis of all of the cases to which I've referred the court. And that is the principle which, in my submission, the judge was bound to adopt and would have adopted but for his own view of the significance of the criminal law. And paragraph 76 incorporates all the necessary findings of fact. The deceased chose to sit on the windowsill and accept that risk. There was no hidden feature or element. And there is no basis, in my submission, upon which this court would be entitled to upset that finding of fact. The only other point on which I wish to reply is the way in which this point is addressed by the editors of Clark and Linsell. My learned friend has copied and directed the court's attention to the chapter in Clark and Linsell dealing with the defence of Volenti non fit jury. I handed up yesterday copies of the section in Clark and Linsell dealing with occupiers' liability.
Yes, we have that, thank you.
And I invite the court to place that at the end of that divider. You don't have dividers, but to place it after the
If we
Clark
have,
and
that's
Linsell
where
sections.
we put it.
And the editors of Clark and Linsell deal with either the insuperable point or the section 2.5 point, whatever one calls it, under the heading Obvious Dangers and Ordinary Risks. Does the court have that, 1132?
Yes, thank you.
And the way in which it's put in this part of Clark and Linsell is this: no duty is owed as occupier in respect of dangers which are entirely usual or obvious to a reasonable visitor. That is the principle. And then there follow references to 11 cases. Some of them are cases to which I've referred, there are others, and they are identified in the footnotes 183 and following. Footnote 185 refers to Staples and West Dorset, Derby and the National Trust, English Heritage and Taylor. Footnote 194 refers to Cosmar Village, Villa Holiday, which is diving into shallow water. Anyhow, they identify 11 cases which exemplify this principle. And the judge, in his judgment in the present case, identified, I think, 6 or 7, some of them overlapping. And so, as I pointed out yesterday, there are lots of cases which support this proposition, i.e. no duty is owed as occupier in respect of dangers which are entirely usual or obvious. And there are no cases in which a claimant has succeeded in the face of a finding that the danger which led to his injury was obvious. And the judge in this case has so found. Maybe that's all I wish to say in reply.
Thank you very much. That's most helpful. Very well. Well, thank you both very much indeed, both for your oral submissions and also for the written material, and also, of course, Mr. Evans.
Yes, but I do have copies of the day case, if that would assist.
Thank you. You won't be surprised to hear that we're going to reserve our judgments, and we will get those to you as soon as possible.
I don't know what my learned friend's handing up, but I haven't...
Sorry, Ronnie, that was a day case.
Oh, day that
Yes.
to yesterday.
We were anticipating it. Were you not anticipating it?
No, I haven't considered it, but...
Well, do you mind us having it?
No, not at all. Not at all.
Thank you. So draft judgments will be sent out in the normal manner for typographical and other minor factual errors, not, of course, as an invitation to treat or re-argue. I would hope that you would be able to agree any consequentials in writing between yourselves. If not, we'll deal with any applications in writing. Thank you all very much indeed.
Court rise.